Hello and welcome back to the channel. Today we will be discussing about how to register a trademark in Israel. Trademark registration in Israel is granted by the Trademarks department under the Israel Patent Office for a period of 10 years. Step 1 involves designing a mark. The first step in the process of registration of a mark is designing the mark. Such marks should be designed in accordance with the provisions of the Trademarks Ordinance. A trademark in Israel can be framed only in the form of words, designs, letters, characters, numerals, sounds, shapes and colors. However, smells have not been permitted to be registered as a trademark in Israel. Step 2 involves determining the classification of services and goods to be trademarked. Like other major script signatories, Israel too follows the NIS classification for the classification of services and goods while filing an application for a mark. Accordingly, a mark is allocated. A multi-class application can also be filed. It is always advised to file in as many classes as possible, as after the filing of the application, no further additions can be made with respect to the classes. Step 3 involves conducting a prior trademark search before filing the application. It is not obligatory to conduct an online search before filing the application of registration. However, official trademark availability searches are available before the filing of the application. An official trademark similarity search only covers a single international class. The official fee for the trademark search is $180 per class. The Israeli Patents Office extends the search to additional relevant classes. These searches are not always fully covered depending on the list of services and goods with search request. A search for a device mark is done only for one class. Step 4 involves filing the application for the registration of a trademark. The following formalities have to be taken into consideration while filing an application for the registration of a trademark in Israel. Power of attorney on behalf of the applicant and in favor of the attorney has to be filed at the Israel Patent Office in order to file a trademark. The application is supposed to be filed online at the Trademark Online system. A filing date has to be obtained and the following information has to be provided: the name, ID number or corporation number, contact details and address of the applicant, a representative mark, the details of the representative where a representative is involved in the process of filing, a list of services and goods for which the mark is to be registered, details of the priority claim, power of attorney when a representative is involved in the application process, multi-class applications. The particulars of the application are sent to the applicant within a few days of filing and will be sent to the applicant's agent not later than 3 days if the application is filed online. Step 5 involves examination of the mark by the Israel Trademarks department. The examination of the trademark application is done both on technical grounds and substantial grounds. The substantial grounds include examining the application on all the absolute and relative grounds of refusal. On the other hand, while examining the technical grounds, the examiner ensures that all the technical requirements have been fulfilled in the application, such as payment of the additional fee, filing a power of attorney, etc. Thereafter, the examiner moves towards examining the wordings of the services or goods and the classification of such goods and services. If the description of the services or goods appears to cover other additional classes than those initially mentioned in the application, the examiner may ask the applicant to add classes to the application or change the classification altogether. The Trademarks Office then examines the mark on both the absolute grounds and relative grounds. Initial refusal based on the cited mark can be overcome with the help of letters of consent made in favor of the applicant. However, the examiner is not bound to cancel a citation after the submission of a letter of consent. The representatives or the applicants themselves are required to respond to the rejections made by the Trademarks Office within a period of 3 months, which is again extendable. If the application is denied, rejected by the office, then the applicant has the provision of filing an appeal against such denial. The applicant or representative has the option to appeal against such decision within a period of 3 months from the date of denial. Thereafter, the applicant can request a hearing before the registrar. The decision of the registrar is itself subject to appeal to the district court within a period of 30 days. The applicant has the option to appeal the decision of the district court to the Supreme Court within a period of 30 days. Step 6 involves publication of the applied mark allowing opposition. If no objections are raised in the application by the office or after curing all the deficiencies in the application, the office publishes the application for a period of 3 months, allowing third parties to file oppositions against the proposed mark on both the relative and absolute grounds of refusal. The absolute grounds comprise the mark being deceptive, descriptive, harmful to the public policy, or the one that encourages unfair competition. Relative grounds of refusal include the marks that harm the third party's property rights or the ones that are similar or identical to another business name. The registered trademarks can be cancelled by the third parties only on those grounds of relative and absolute refusal raised at the time of opposition within a period of 5 years from the date of trademark registration. Another ground for the removal of the trademark from the registry is that the mark has not been used for a period of 3 years preceding the petition for removal. The opposition and cancellation proceedings involve the submission of statements, filing of evidence in affidavits, cross-examination proceedings before the registrar, and written submissions. For filing an opposition proceeding, it is not necessary that the trademark may be registered. The brand owners are allowed to file claims against the trademark applications and trademark registrations on the basis of common law rights accrued through the use of the trademark and also on the basis of the international goodwill associated with the trademark. Step 7 involves registration of the trademark. After satisfying all the claims of opposition from the third parties and curing all the deficiencies raised by the department, the application for trademark registration moved towards the stage of registration. The Trademarks Department under the Israel Patent Office issues the certificate of registration and sends the certificate to the applicant or its representative via email. The office does not charge any additional fee for granting the registration. The rights accrued as a result of registration commence not only from the date of registration but from the date of application. They are backdated to the application date. The initial term for the registration of a trademark in Israel is a period of 10 years commencing from the date of registration. Let us now know the information to be furnished in the application for trademark registration in Israel. Following is the list of information that is supposed to be furnished at the time of filing an application for trademark registration in Israel. The design of the mark, the services or goods claimed in the mark, priority claims if applicable, name and address of the applicant and the state country of incorporation, specifications of the applicant's representative, power of attorney in favor of the attorney who is filing the application to the trademarks office, citizenship of the applicant, and the type of mark. If the application of the trademark application has been made in a particular color, then the trademark will be limited to the color of the mark and not to any other color. However, if the mark has been filed with the black and white, then it will be registered for all the colors. Therefore, it is suggested to submit the application in black and white only so that maximum protection can be claimed for the mark. For more such information, please subscribe to the channel.